Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney in Atlanta, Georgia. I have offices in Cumming and Jonesboro as well. Today we're going to talk about non-consumer debt and bankruptcy. First, let me offer you this disclaimer. We're a debt relief agency proudly assisting consumers in filing bankruptcy under the U.S. Bankruptcy Code. There is no attorney-client relationship with the viewer of this message unless there is a fee agreement. We would have to meet with you individually to offer you applicable and accurate legal advice. This message is intended only for educational purposes. So let's say you've incurred the majority of your debt through non-consumer methods. And when I say the majority, I'm referring to dollar-wise as opposed to number of creditors. For instance, I'm not referring to two non-consumer creditors versus one consumer creditor. Let's say you have $50,000 in business debt through two non-consumer creditors, which is essentially saying a business creditor, a business venture creditor, and then you also have a $200,000 mortgage. Even though you have more non-consumer creditors, the majority of your debt is consumer debt. I'm talking about typically the person who has issued a pretty big. They've either gone out and tried to form their own business, or they've issued a pretty big personal guarantee on a debt. They've a guarantee. They tried to invest in real estate or something, either homes for renters or maybe like a commercial property. They're trying to develop a commercial property. They've issued personal guarantees in exchange for getting the loans. So they have multi-million dollars in debts through their personal liabilities. They're what's called a majority non-consumer debtor. Why does it matter in bankruptcy? Well, the primary reason it matters is that debtor, who is a majority non-consumer debtor, their exceptions been carved out by Congress to make Code Section 11707, 11 USC 707B not applicable to them, because you might have someone who makes pretty good money, is in therefore would ordinarily be ineligible for a Chapter 7 discharge on the basis of 11 USC 707, meaning they make too much money under the means test for Chapter 7. Also, on the basis of their personal guarantee, they have too much debt for Chapter 13. So in that scenario, the only their Chapter 13 is debt limits. They're over the debt limits. So the only bankruptcy section that would apply to them in that scenario would be Chapter 11. However, in this scenario, there's an exception to allow them to do a Chapter 7. So theoretically, they could have more disposable income than someone who is a majority consumer debtor, and consumer debts are typically car loans, mortgages, credit cards. They could have more debt than someone who's typically a consumer debtor, but so you could have the majority consumer debtor who doesn't qualify for Chapter 7 because they're showing $500 a month in disposable income under the means test, whereas the person who's showing $1,500 a month disposable income under the means test could theoretically qualify as a majority non-consumer debtor and get a Chapter 7 discharge. Now, that debtor might also have substantial assets, so there might be a liquidation of the assets. But as to just qualifying and being eligible for the discharge, they are qualifying under majority non-consumer debtor standard. Why is that? Basically, Congress theoretically carved out this exception for people who take business risks, so that you wouldn't take a business risk and then not even really be able to file a bankruptcy under the bankruptcy chapter that you really wanted to file under. That is an exception carved out for the business debtor. So when you have someone with substantial debts, you need to see if the majority of their debts are for non-consumer purposes.